Hello there, my name is Avedoshain Leon and my University of Hertfordshire student ID number is 250-13797. Today I will be advising Sulaiman on his legal rights and remedies under the Sales of Goods Act 1979. Following his purchase of furniture from Amjad Furniture Store, let me begin by summarizing the key facts. Sulaiman owns a restaurant that is being renovated. He visits Amjad Furniture Store and places order for 25 extra large marble tables, 100 velvet dining chairs and one leather sofa set. During the sales process, he receives several assurances from the seller advisor 7. On the agreed delivery date, Sulaiman does not receive what he ordered. Instead of 25 extra large marble tables, he received 10 medium sized marble tables, 9 wooden tables and only 1 extra large marble tables. The chair appears to be grace marks and the scraping and the leather sofa causing his daughter to develop a rash, raising concerns about the safety and suitability. When Sulaiman complains the request to reject the goods, the store tells him it is too late and he must accept them. Now let's consider his right. The relevant law is Sales of Goods Act 1979. The reason behind that, this is a business to business transaction because Sulaiman is purchasing furniture for his restaurant and the store is also a business. I divided the problem into 3 parts. The first one deals with tables, the second with chairs and the third with sofas. Let's deal with the issue on table. Sulaiman ordered 25 extra large grey marble tables. Instead, he received 10 medium marble tables, 9 wooden tables and only 1 extra large marble tables. In here, relevant act is section 13 of Sales of Goods Act 1979 and it says that goods sold by description must exactly match the description. That means any change, no matter how slight, is subject to rejection because it is a condition under this section. In here, he ordered extra large, but his supplied goods are medium in size, material was replaced with wood, and also quantity doesn't match with the order. There are not minor defects, the fundamental deviation from the contractual description. As per Arcos Limited versus Ronasen, even a minor deviation from the contractual description constitutes a breach. Buyer may reject the goods. The goods must exactly match the contract description. In here, Sulaiman gets totally different types of table. Following Remor and Co. 1921 case, goods that match in quality but not in description can be rejected. The duty to correspond with the description is strict. It is established that even a small deviation entitles rejection, and here the deviation is substantial. Therefore, the goods clearly fail to correspond with the description as per required by section 13 of Sales of Goods Act. Let's move on the next issue on chair. The issue here whether Sulaiman can reject the X-display chair or claim damages on the basis that they are not satisfactory quality under section 14.2. The Sales of Goods Act 1979, the section 14.2 states that goods must meet the standard of the reasonable person would regard as a satisfactory, taking into account any description, price and circumstances of sale. Defects must be either minor and expected, fully disclosed before the sale. Here, Salman told Sulaiman that chairs were X-display in good condition and had only minor wear and tear. But when the chair arrived, Sulaiman found grace marks, scratches and likely even more defects inside the unopened boxes. These defects go beyond what he was told, and reasonable buyer would not expect this level of damage from X-display's item. Applying Roger versus Parrish, this case established that even a small or minor defects can amount to breach the satisfactory quality if they affect appearance, finish or overall condition in the goods. In here, grace marks and scratches clearly affect the appearance and finish of the chair. Even if X-display's item can have wear, these defects go beyond what would be reasonably expected. So, under Roger versus Parrish, the chair fails to satisfactory quality test because their visible condition is not acceptable, even though defects might seem minor individually. Applying another case, Bernstein versus Pamson Motors 1987. This case confirms that goods must be free from any defects that weren't disclosed to buyer before the sale. In here, Salman only disclosed the minor wear and tear. He did not mention grace marks, heavy scratches on deeper defects. Therefore, they are disclosed faults breach the standards of this case. The presence of the additional defects in the unopened boxes further extends Sulaiman arguments that these defects were not explained, not expected, and not acceptable under section 14.2. Defects disclosed at sales are excluded, but undisclosed defects breach section 14.2. I'm moving on the next issue, that's SOFA. The issue is whether Sulaiman can reject the leather sofa or claim damages on that basis that it was not fit for the specific purpose. He clearly said that it must irritate individual with a skin condition under section 14.3 of the Sales of Goods Act 1979. Section 14.3 of Sales of Goods Act states that where the buyer makes known a particular purpose, the goods must be reasonably fit for that purpose, provided the buyer relies on the seller's skill or judgment. To satisfy section 14.3, the buyer must show 4 particular things. The first one, communicating. In here, Sulaiman expressly stated that needed a sofa would not irritate customers with skin condition. This clearly satisfies the requirement of the communicating a specific purpose. The second one is the seller advised or reassured them. So Sulaiman then reassured him that leather was the highest quality and there will be no issue. Third one is the buyer relied on that advice. Sulaiman relied on that advice when deciding to purchase. Applying Baldry versus Marshall in this case, the buyer asked the seller for a car suitable for touring, and the seller recommended on. When car failed to meet the purposes, the court held the seller liable because the buyer had relied on the seller expertise. The matter same in Sulaiman cases. And the fourth on that goods failed to meet the purpose. Following Grant versus Australian Knitting Mills 1936. In this case, the buyer bought woolen underwear and later developed dermatitis because of the fabric. The matter same in that scenario that leather sofa caused a skin reaction shown a Sulaiman daughters developing a rash. So it is crystal clear that breach of section 14.3. Let's go available remedy for Sulaiman as per section 15b of Sales of Goods Act. When Sulaiman asked to return the goods, but Sulaiman said it is too late. Let's see whether Sulaiman can reject the goods under section 15b or not. Section 15b states that when there is a breach of implied term, the buyer may reject the goods, rescind the contract, and recover price. A buyer the right to reject only when they accept the goods under section 35, but acceptance only occurs when the reasonable time when the buyer intimates acceptance. After reasonable time, they keep the goods without rejecting. They do an act inconsistent with the seller's ownership. Here, the wrong tables arrived, the chair were barely inspected, the sofa was used once and caused a rash. This is not acceptance. Following Clegg versus Ollie Anderson, buyer can reject even after months if defect exists from delivery. Other on J&A Stitchy versus Lyot, buyer can delay acceptance until knowing full defect. Sulaiman notified the store immediately, so rejection is valid. Under section 30 and section 31 of Sales of Goods Act, a buyer is allowed to reject the goods where the seller delivers the wrong quantity and the wrong type of goods, or a mixed delivery that does not match what was contract for. In Sulaiman's situation, the mismatch is very serious. Sulaiman can reject the entire batch of tables, not only the incorrect ones. Following section 31, section 30 and section 15b, he can reject all the tables, all of the chairs and also the sofa, and demand repayment. He also can claim damages under section 53 of Sales of Goods Act for diminished value of chairs, replacement cost, possible medical damages from the sofa reaction. I am going to conclude that each of the items Sulaiman purchased breach a different section of the Sales of Goods Act. The table breach section 13 because they do not match description at all. The chair breach section 14.2 because they are not satisfactory quality and contains defect what were never disclosed. And the sofa breach section 14.3 because it was not fit for the specific purpose Sulaiman made known to the seller. Because all the categories of good fail to meet the legal standards, Sulaiman is fully entitled to reject the goods and cancel the entire contract and claim damages under the Sales of Goods Act 1979. He should now write to the store immediately, formally invoking his right under section 13, 14 and 15b, and request either a full refund compensation for the losses he suffered. Thank you.